intellectual property. Our goal each semester is to cover various aspects of intellectual property that might be of value to engineers and give it in a perspective that's not generally found elsewhere and in a way that is hard to otherwise acquire on your own. The first half of the course is fundamentally focused on patent claims because that's really the essence of inventions. If you can't define your invention in a patent claim or an invention definition, you can't then enforce a patent or decide whether somebody's infringing or decide whether a patent is valid. You don't know how to determine a reasonable royalty if you're wanting to license. So it's very important to understand the fundamental principles underlying patent claims. So that's what basically the first part of the course is focused on. The second part of the course covers everything else. And that is more of a conventional type of course where we cover things that are in the handouts, that we cover them on PowerPoint. You sort of learn what's on that and you understand things. The first part of the course is more analytical and it tests your ability to think. And I suspect for many of you, when you're done with this course, you will think about things in a different perspective than you'd ever thought about them before. Hopefully it will make you a more powerful thinker. I had up on the display earlier image of a patent to Abraham Lincoln. A lot of people don't know that Abraham Lincoln started out as a surveyor and then eventually was an inventor and got a patent, one of the early numbered patents. And it's my contention that I argue, whether I'm right or not, I'm not sure. It's my contention that if you really understand patents, you will be better off in dealing with many aspects of life. You will have a better ability to think about things. And while Abraham Lincoln is the only president that has obtained a patent, a lot of other very successful people have had knowledge about patents and patent claims. And in my perspective, it has enabled them to think about patents in a way that makes them more powerful intellectually. If you take one handout of each, that'd be fine. That's much simpler than buying a textbook at the bookstore. There's no textbook in this course. One of the handouts sort of outlines what the weighting is for the things that are done in this course. In general, the purpose of this course is to teach you fundamentals. It's not exhaustive. This particular semester is interesting because Congress has passed a new law which changes some of the rules for patents. And so you will be learning the new rules, and you can forget all of the old rules that everybody else has learned heretofore. And so we'll discuss from time to time the impact of the America Invents Act on the recently passed act on the patent rules as to what's patentable and what's not. The goal is to weight the greatest amount of work in this course towards the first part of the semester. And unlike your other courses that are weighted towards the end of the semester, this one is weighted more towards the beginning of the semester. So when your other courses get a little bit intense, this one will tend to slack off a little bit. And that people seem to like that somewhat in fitting in their workload. We do have a final examination, but unlike most courses, our final examination is as an elective as to when you want to take it. The university requires that the finals examination period be assigned a slot for this course, but most everybody, and sometimes everybody, elects to take their final examination on the last regular class period during what's called dead week. And they like to get that over with so that when they have their regular final exams, we're out of the way and we don't get in the way and they can maybe go home early, because this tends to schedule towards the end of the final exam period, and if you don't have this to go to, that everybody seems to like that pretty much. So we will follow that schedule. I've handed out a course outline that sort of outlines what will happen on whichever day. It's very important that you are here when we are doing something in class. I don't require that you attend class if there's nothing happening on that day and you want not to, and just get the handout that next week. You're entitled to do that. Occasionally during the class period, I will give suggestions as to what might be on the final examination, and you wouldn't get that if you didn't come to class. But everything in the final examination is derived from the PowerPoints that you'll be handed out. And so if you learn that, you're in good shape whether you came to class or not. But if we're giving an in-house exercise or in-class examination, you have to be here for that. That's the only required attendance. Some of the classes are pretty much lecture. Others of them are pretty interactive. And those are a lot of fun to do that. And I will look for your input when we do those things. We posit hypothetical inventions and try to write claim definitions for those. And you folks will pick out whatever invention you want to work with at random, and then we will synthesize some prior art, and then we'll try to write a patent claim to cover that invention in light of that prior art that exists. So let's begin with our lecture. Let's first cover what is generally encompassed within intellectual property. There are basically four categories normally considered. First and most challenging are patents. Second are trademarks. Third, copyrights. The simplest of all, and trade secrets, the one which requires no government involvement whatsoever. They happen automatically as long as you try to keep them secret and you let people know that they're secret and they agree, then you have trade secret rights. All four categories of intellectual property function only to exclude others or to provide a royalty from others. They do not provide any inherent right of use for the owner. A lot of people have the understanding that if you own some intellectual property right, that gives you the right to do something. It doesn't. It only gives you the right to keep other people from doing that which you own. It's only an exclusionary right. Intellectual property rights keep other people from your property, but they don't say whether you can use your property. Using your property may violate some statute, some law. It may infringe other people's patents. It may violate somebody else's trademark or somebody else's copyright. The only thing you get when you have intellectual property is the right to either exclude someone else or the right to get a royalty from those other people in the event you don't want to or the law doesn't permit you to exclude them. That's fundamental. And I can tell you that there are some people, when we get to the final examination, still haven't learned that, but it is a very basic principle. Most everybody understands it. We repeat that many times, but it's really hard to get your arms around that.
How can you file for a patent if you're using someone else's copyright?
I don't quite understand the question. You can file for a patent on anything that you've invented.
Because you said to exclude others, and you said something like you can't use it because it infringes on someone's copyright. Then how would you be able to obtain that patent?
The question is, if in order to disclose your invention to the patent office, it is necessary to use somebody else's copyright in that disclosure, that would be a privileged use. It would be a fair use of the copyright, and it would not be a violation to the extent it was merely to perfect that legal right. The moment that you start to sell it commercially or whatever, then you're violating that copyright. But in order to just secure your right, my belief is that that would be what's referred to as a fair use of the copyright. There are some current cases challenging whether or not a person has to pay a royalty to tell the patent office about prior art publications that are copyrighted. And you need to tell the patent office about prior art for them to consider it, but if you make a copy of that prior art and send it to the patent office for their consideration, then is that a copyright infringement? And I think how those either have come out or are likely to come out is that that will be deemed a fair use privileged permission for that purpose of establishing legal rights. That's a good question. And I would also comment, that I love interruptions and questions. The more the merrier. I'm real happy anytime you want to do that. There typically in this course will be one course where I bring cookies. And in order to get a cookie, you have to ask a question, and then you get a cookie. So that's one of the more interactive courses, it turns out. Okay, if we want to look more particularly at patents, patents are the government-granted right to exclude others from or entitle one to a royalty from any one of these things: making, using, selling, offering for sale, or importing of an invention. If someone has a patent, they can exclude others from any one of those things if in fact what that other person is doing is an infringement of that patent. In order to get a patent, you have to have a timely application, and patents will expire after their initial term ends. Typically, it's about 20 years from filing. And patents can provide protection for novel ideas when incorporated into products or methods, but an idea per se isn't patentable. It is only when incorporated into products or methods that it becomes patentable. Yes?
You mentioned how having a patent it restricts people from using what you came up with, right? So
well, a patent lets you exclude people.
It's exclusionary.
Yeah.
So then how do you get the rights to sell your product or to use your product?
There may be no need to obtain any rights because you may have the only patent that impinges that, and there may be no statute, or there may be 500 impinging rights. That states may have regulations. You may have to get approval from EPA. You may have to go to OSHA. You may have to go to the state to get a permit to construct this thing. You may have to go to the Nuclear Regulatory Agency to get permission to use the radioactive material in the device or whatever it is. And then, of course, if you make a product that's not safe, you run the risk of violating product liability laws. And so there can be all manner of things that get in the way of using. It's just like if you own a piece of real estate, you can keep people from trespassing on it, but that doesn't mean you can build a building until you get the permits and your code and there's zoning and all other kinds of things. Usually when you think of a patent, you're thinking of what's referred to as a utility patent. Utility patents only address the functional aspects of inventions. Examples would be Edison's light bulb and the Wright brothers' airplanes. Things that actually function in a particular way, you get protection as to that functionality, either broadly or narrowly, but it's some protection of the functionality. And people who use the functionality that you've covered with your patent infringe. And if that functionality is shown in prior art and things other people did before your invention, then that patent claim would be invalid because you can't get a patent on things that are not new. There's also a category, much less used, referred to as design patents. And that's sort of the opposite side of the coin. Design patents only address the non-functional aspects of the invention that are visible. An example would be a novel aesthetic shape of a television remote control, where the shape really doesn't lead to it working better as a remote control or being easier to grasp, but it's just pretty. And so you can actually get a design patent on a remote control just on the aesthetic shape. It doesn't do much good to have a design patent except for people who copy the exact shape, then you can sue them, because someone can achieve the same function by just changing the appearance. And so design patents are of much less value. They're easier to get, but they're harder to enforce and they're easier to design around. Then there's a third category, which is quite rare, but for completeness we'll mention that there are plant patents that only protect asexually reproduced non-tuber plants. An example would be a novel rose or an apple tree. Now, second category is trademarks. keep in mind that with patents, you have to go through a rigorous procedure with the government in a timely fashion that is somewhat involved and expensive to get your rights, and those rights are of limited duration. With trademarks, you don't have to do anything other than use the trademark in commerce. There is a procedure where you can file for a registration with the federal government, or actually with the state government as well, but primarily the federal government. And if you go through that procedure, you will have slightly enhanced rights. But if you choose not to, you will still have rights in the trademark simply by using the trademark in commerce. And your rights will be superior to all others who come later in connection with the same goods or services in the same territory that you use the trademark. So trademarks are nice because you really don't have to do anything. You just pick a mark, use it, and you have the rights, assuming you didn't use something somebody else had earlier. Don't have to go to a lawyer, you don't have to do anything. Then if somebody copies your mark, you can sue them and you can win. Sometimes it's desirable to get a federal registration to reinforce those rights. Sometimes, particularly for small companies, it's better just not to worry about it because you have other concerns with your limited time and money. Now, overseas, trademark rights are much better served by getting a federal registration, but most of you will be focusing on the United States as your market, and there it really doesn't matter for most inventions. If you have plenty of money, you might as well get the trademark registration if that's not going to give rise to conflict. Otherwise, just go ahead and use the trademark. Copyrights, another really easy thing. Copyrights are granted to exclude the copying of expressions of ideas. Generally, copyrights are in the forms of writings, computer programs, works of art, and the like. For copyrights, there is no protection for the underlying ideas that are disclosed in the copyrighted material. It's only a protection for the way that you've expressed those ideas. And it must be, in order for you to get copyright protection, that there are a lot of different ways that that same idea could be expressed. If there's only one way you can express that idea, then copyright can't provide protection because it would then preclude the interchange of ideas among people, and that's not copyright's function. Copyright's function is to protect the originality of you preparing something so that somebody doesn't avoid the work of writing up their same description on their own. They would just copy you. That's not something that's favored. So copyrights, again, happen automatically. The moment that you write something down, you have a copyright in that. If you want to sue somebody and get lots of money, then there is a registration procedure that you go through. We have one lecture devoted to copyright. They last a long time, at least 70 years, and carry with them benefits in the award of attorney fees. If you have to spend money to sue infringers, you generally can get payment for your litigation fees as well as the damages that you can prove. Trade secrets. Trade secrets cover any information that's of value which is not generally known or readily ascertainable by others, and for which reasonable measures are taken to maintain confidentiality. Skills of one trade necessary to generally perform that trade cannot be trade secrets. You can't use trade secret law to prevent somebody from practicing their profession. If they know some trade secret, they're entitled to practice their profession, just that they not use the particular secret that they know. There's no registration process for trade secrets. It's free of government involvement until you're trying to enforce it, and then you need the courts. Rights arise automatically and last as long as confidentiality is maintained and the information remains not generally known or readily ascertainable by others. Trade secrets can last 100 years. 200 years, whatever. Not a problem, but most things of value that are a trade secret, people independently come up with, they get published, and then upon publication, the rights in the trade secret are extinguished. Okay, now we're going to go on to really the heart of the next half of our semester, and that is patent claims. At the end of every patent, there's one or more numbered definitions of inventions, which are referred to as patent claims. And it's very important when patent claims are written that the correct words are chosen to define the invention. If you choose the correct words, you will get broad coverage and yet still not have those words describe what is in the prior art. That's the goal. You want to get as broad a coverage as you can without also encompassing things that have gone before or obvious from things that have gone before. The choice of the words that are used in the patent claims is the best indicator of the scope of a patent. And the patent claims are the major factor in determining whether a patent is infringed or whether a patent is valid. Claims are generally not the focus of people who read a patent. Almost everybody who's just not skilled in the patent arena, who gets a patent, looks at everything but the claims. You look at the claims and your eyes sort of glaze over. You know, what is all of this? It makes no sense. But that's really where the value is. People look at the abstract, people look at the drawing, people read the description in the patent, and that's all fine, but it doesn't really tell you what the patent covers. What the patent covers is defined by the patent claims. And if you understand the patent claims and know particularly how you might even go about writing a patent claim, that's where the power comes from, the understanding. Talk about a diamond pin story. I don't know if you've heard about this or not, but a man walked on one side of a street to a restaurant at night and lost a diamond pin on the way. As he walked back, he searched for the pin on the other side of the street. He said he looked there because the light was brighter there. That's what people do with patents. Patents are fine to read the description, it's fine to look at the drawings, but the patent claims are often hard to read and hard to understand, even though that is where the value lies. So we focus significantly on fundamental basics of patent claims. Just like football players oftentimes practice fundamentals of how to block with hours and hours of practice on blocking rather than the complex plays that they might institute in a game, it's really important that you understand the fundamentals, and that's where we come from here. That I think is really hard to get elsewhere. As an example of how hard it is to really write patent claims, it's been my observation that it takes about a year for an apprentice patent drafter to gain reasonable skill in drafting patent claims. Even the most experienced people can often benefit from input from another's perspective in the patent drafting process. The very brightest of students that we hire in our law firm find their first year of practice of patent law much harder than they had imagined. It's just a difficult skill to learn. But by learning the process of writing patent claims, you can gain tremendous insight into inventions in science that you would have difficulty learning any other way. Here is my prime example. I don't know whether you recognize this man or not, but from age 23 to 30, Einstein worked as an examiner at the Swiss Patent Office in Bern. His job was to understand and deal with inventions and discoveries and how they are defined in patent claims. That's what patent examiners do. They read patent claims and they try to figure them out. At the age of 26, while still employed as a patent examiner, Einstein made 3 of his greatest contributions to scientific knowledge. you tend to think of great progress in science as coming from universities. Albert Einstein's background was the Swiss Patent Office. I think that's not a mere coincidence. When you deal with new inventions, it's different than anything else that you've dealt with before. You can't look up the answer as to how to define this new invention because nobody has written about it. Nobody has analyzed it because it's a new concept. The moment that you realize it's not new, you're done. You can't get a patent on something that's not new. So every project that you have to try to define, you have an absence of a resource to look up what you need to know about how to define that invention. So it requires a skill and talent that none of your other courses, or very few of your other courses, ever deal with. Because almost all of the other courses you deal with, somebody has studied this and got a PhD thesis on it or whatever, you can look it up. You can say, this is how this guy did this. Let's see how somebody else did it. I'll pick among those. But if you have to write the definition for a new invention, nobody's written that definition before. There's no place you can find that. You have to figure it out on your own. So you have to develop different techniques for analysis than you're accustomed to using in connection with other things that you deal with in engineering. Now, I point out 3 steps that must be taken to define a new invention. First, you find the factors that distinguish from the prior design. There's got to be differences. If there's no difference, you don't have an invention. It's something old. And then you determine the appropriate level of abstraction. How much abstraction do you want to have in defining each of these distinctions? And third, you create an invention definition from the abstractions that you've determined. There's more to it than this, but that's fundamentally what it is that you do. And the value of invention definition skills are multiple. For engineers and scientists, if you distill an invention to a clearly defined set of terms, that clarifies further thinking about the invention, enhancing further innovation and discovery in the process. Invention definitions are often at the core of licensing of patents and trade secrets. If you really understand what the invention definition is, you have a much better ability to determine an appropriate licensing dollar amount and the nature of the terms that should surround the licensing agreement. In patent infringement lawsuits, one not only needs an understanding of the patent claims, but one needs to carefully reassess whether a better invention definition involving insights gained after the patent was issued should be woven into arguments to aid the persuasive process. And for trade secrets, the process of drafting an invention definition for each trade secret is a part of the process for a clear assessment of the related legal and business issues and the nature of design alternatives which may avoid infringement. These are all things that flow from understanding how to write definitions for inventions. In order for us to understand how to best write patent claims, the most helpful approach is to define simple mechanical inventions. The patent system allows for patent coverage for any new, useful, and unobvious process, machine, manufacture, or composition of matter, or improvement thereto. Now, by using very simple mechanical inventions, it's very similar to that which your physics professor did when you took physics. You studied things that happened in nature with the assistance of massless springs, frictionless pulleys, and other things that don't really exist in the real world in order to define the very concept they were trying to teach in a pure fashion. We do the same thing here in defining inventions using hypotheticals and things that don't exist in the real world to clarify understanding of the principles. Lots of examples of different things that are patentable, and I'm sure that you see all the time on products that you look at patent pending or patent numbers or whatever. There are vast numbers of patents that issue, and they cover all manner of things that you see in your day-to-day life. Now, when you want to do research with regard to patents on the web, there are lots of choices. I typically use the uspto.gov website. Sometimes the display of the images is not too easy on the computer if it isn't set up right. Google/patents is very good and easy to use and user-friendly. There are other sources as well. If you just want to print out a patent and you know the patent number, the bottom two, pat2pdf.org and patentfetcher.com can be used just to download a patent quickly for printing. Lots of words that you can use in writing patent claims. These are just some examples to get you thinking. I'm not expecting that you choose from these in anything that you do, but just to let you know that there are all kinds of different terms of different levels of abstraction that you can use for writing patent claims. Now let's turn more particularly to a couple of examples of good patent claims and bad patent claims. Bad patent claim is the combination comprising a snow shovel and an ice cream cone. A snow shovel and an ice cream cone does not distinguish from prior items because both a snow shovel and an ice cream cone are old, and there is no recited relationship between the two in the patent claim. Now, if instead you had used a good form, and it says the combination comprising a snow shovel and an ice cream cone connected to said snow shovel, that may well be novel, since the recited connection between the two distinguishes from the common knowledge one has about each. And I don't recall ever seeing a snow shovel connected to an ice cream cone before, so this may well be novel. And if it's novel, then you have some hope of getting patent coverage on it. I'm not sure why you would want that particular patent coverage, but it's possible. I've never seen it, yes.
So is the omission of you defining shovel as snow shovel, is that important at all?
If you had just said shovel instead of snow shovel, you'd have had a broader claim, and that would be fine. The point of this exercise is to show that you need a link between the two in order to avoid the claim reading on the prior art. If there's no link between the two, the claim reads on the prior art that's not linked. But it would, if you wanted to have a higher level of abstraction, you could say just a shovel, which would be a broader claim. And I don't think I've ever seen a shovel and an ice cream cone connected to the snow shovel. And you might even broaden it further. You could say a shovel and a foodstuff. The foodstuff being connected to the shovel or the tool. But then you get a question as, can you use foodstuffs as tools? And so you sort of lose the distinction there in the patent claim. But that's just the kind of thing that we will be doing, and that's exactly the way you ought to be questioning definitions. That's great. In talking about parts of a patent claim, there are really two parts that the courts tend to treat differently. The first part is the preamble, where it says the combination comprising. And normally that doesn't affect the meaning of the claim. Whatever you say before the word comprising or consisting or whatever it is your lead in, normally that's not used to interpret the patent claim unless the body of the patent claim that follows somehow links back and draws upon that preamble, in which event then the preamble can be used to determine the claim scope. The body of the claim is everything except the preamble. Now, we're going to use this example to talk a little bit about invention. This particular invention is a doorstop. And the doorstop is a bent wire that hooks over a hinge plate to prevent the doors from swinging further than the horizontal member of the doorstop would permit. Now, example claims for this doorstop Could be many. It's left up to your imagination how you might write a definition of this doorstop. One definition might be a doorstop comprising a hinge and a wire with 4 separately spaced bends adjacent said hinge. That describes that doorstop. That could be a patent claim. I don't believe it reads on any prior art that I'm aware of, so it might well be a valid patent claim. You might choose not to do it that way. You might simply go to the second definition that's up there. A doorstop for use with a pair of hinge plates comprising a unitary rod with a portion extending laterally between the 2 hinge plates and another portion used for coupling to said pair of hinge plates. That's a little bit broader, but it's differently oriented. It's narrower in some respects, but mostly broader. A third definition, equally appropriate, a doorstop for use with a pair of hinge plates comprising apparatus which removably hooks over one hinge plate to position a spacing member between the pair of hinge plates. Doesn't say anything about there being a wire or there being bends. It comes at it from a much higher level of abstraction. And so here we have a broader claim. Now when you write a patent and you file it with the patent office, you're not sure which of these claims is best, so you generally have lots of claims. And if any of them survive, then you have that claim. And you're not even sure once you've got your patent to issue whether all of the claims are going to be patentable if challenged, because you can't possibly know of all the prior art in the world that might surface later, that might invalidate the definition that you've so carefully used. So it's very prudent to have many different ways to define an invention in each patent that you file, so that if it should later turn up that there's closer prior art than you're aware of, at least some of the claims will survive to give you protection for your invention, even if they all do not. And then there's something referred to as a picture claim. And picture claim is not really a picture in the claim, but it is such a detailed claim that it has very much of the attributes of a picture in words. I won't read this clear through, but you can see there are just a lot of different terms that very precisely describe this, and that's fine. It's very easy to get these kinds of very narrowly defined patents through the patent office, but it's very easy also for infringers to design around, because they can just avoid any one of these features and they no longer infringe. So picture claims are good for enforcement against somebody who copies identically, but they're not good for much else. Generally speaking, the fewer words used to define an invention, the broader its scope. It's not a guarantee, but that's usually how it works. Now we talk about prior art. I've used that term to define it more precisely. It's the term used to describe all things done before that are entitled to be used as evidence against a claim of novelty or patentability of a later invention. And what is prior art differs from country to country, because different countries have different standards for what should be prior art. Now we have an example to give further understanding as to what it means to write patent claims. And this gets back to our physics analogy, where we're going to have our massless strings and frictionless pulleys. We're going to imagine things. Let us pretend that there is no prior art of any type, and that this red seat chair was just invented. Okay, there it is. How are we going to write a patent claim? We might initially define the invention as a chair having a seat with 4 legs and a back, the back being attached to the seat. Yet a person later making a backless 3-legged stool would not have their product covered by that definition. And normally you want to get broad coverage for your patent. And so that wouldn't be a very good invention definition. If instead we define the invention as a seat with 1 leg attached to it, we would have a definition which would be much broader and much more suitable to our hypothetical inventor of the chair. So you look at the chair and you see it has 4 legs and a back and a seat, but if you define it as your patent claim as a seat with 1 leg, that's a very good patent definition. The patent definition does not need to include all of the parts of the chair. It just needs to include enough elements to avoid reading on the prior art. And the fewer elements it has, the broader coverage that you get, and the more powerful your patent is going to be, the easier it will be to get people for infringing later. Of course, higher risk that something will turn up to invalidate your claim, but that's why you have lots of different claims in each patent that you file. You try different scopes. But it's really hard for people to understand that when we're writing patent definitions, invention definitions, you do not need to include all the elements of the thing you're trying to define in that definition. You only have to have enough in that definition so that there's at least one element or one combination that prevents that definition from reading on the prior art. That's all you need. Now, if we continue with this hypothetical, defining for this chair, which has 4 legs and a back, we could have just defined it as a leg, because there's no prior art by our hypothetical, or we could have defined it as a seat. And if there's really no prior art, we could have defined it as matter. And that would then have all matter that comes later being infringement. That's a little esoteric analysis, but that's the fundamental concept. Each invention definition ideally has just one distinction from the prior art. Are there questions? Will this be fun? I hope it is. Usually it is. Okay, does anybody have objection if we leave early? Let me see. Hearing no objection, you're welcome to adjourn early. There are 1 or 2 classes where we leave early, and there's a couple classes where I might run over to try to keep the subject matter together. Occasionally I will shift the lecture from one class on to the next if I don't get done, but that's the plan.